Good afternoon, everyone. My name is Danielle Conway, and as I like to always remind everyone, I am the very proud Dean of the University of Maine School of Law. I am excited about this program. We are going to hear from our fabulous faculty. We have a wonderful student body. We have our foundation board members and board of visitor members in our audience. We are truly a Maine law community today. What that means, what a Maine law community means, is that when we deal with important topics, vital topics of the day, we respect the discourse that makes these topics palatable for us to understand various positions. And so that is my expectation for everyone as we discuss these important topics of the day, that we respect the discourse, the important issues that we will be broaching in this discussion. I want to introduce you to a phenomenal third-year law student named Eliza Met. Eliza is going to introduce our faculty participants. Eliza.
Hi everybody, thank you so much for coming. I'm really excited to hear about everything that the panelists will discuss. I personally am pretty lacking in the knowledge areas they're going to share with us, so I'm looking forward to being educated, and then I'm looking forward to the debate, the conversation that will follow, hopefully. In terms of the setup, we're going to have each panelist talk for between 5 and 10 minutes, and so if you could hold your questions until you've gotten the full spectrum of knowledge, that would be fantastic, and we'll just be taking raise your hand and ask your question. That'd be great. So I'm going to do a really brief bio for each of our panelists. So we have Jeff Thaler here to my immediate left. So Professor Thaler is a visiting professor of energy policy, law, and ethics at the University of Maine in Orono, and visiting associate professor of law here at the University of Maine School of Law. He is also assistant university counsel for environmental, energy, and sustainability projects. Professor Thaler has been developing and teaching courses on renewable energy law, energy economics, and law, administrative law, and climate change law and policy, and a new administrative law practicum that has received national attention. To his left is Dimitri Baum. Professor Baum writes and teaches in the field of constitutional law, professional responsibility, employment law, and the judiciary. He is recognized as a scholar and commentator on judicial ethics, judicial selection, and constitutional interpretation. And if you ever listen to NPR, you've probably heard him and his words of wisdom there. Then we have Anna Welch. Professor Welch is a clinical professor overseeing Maine Law's Refugee and Human Rights Clinic and teaching the Immigration Law Seminar. Professor Welch serves as a clinical professor and supervising attorney, as a classroom teacher, and as an advisor to students who are interested in immigration law and human rights. And then we have Charles Norchi. Professor Norchi directs the Centers for Ocean and Coastal Law and Graduate Law Program. He teaches international law, oceans law and policy, international human rights, and maritime law, with additional research interests in jurisprudence law and development, legal anthropology, maritime disputes, and international corporate governance. Please join me in welcoming our panelists.
Thank you, Eliza. I'm going to lead it off, and for those of you who drove in this morning and saw the fog, now that it's gone, this is what we're going to do today. We're going to burn off the legal fog on executive orders. It's hard to see, but these are intrepid law students down at the bottom, making their way to the truth. So remember this image of the inverted pyramid, because I'm going to come back to it. Also, what we're really going to be talking about, I only have 5 minutes. I'm going to try to hit 5 basic points in those 5 minutes, which will be tough, and try to set the table for the rest of the panel, is that we're talking about power. So to channel Melissa McCarthy, who some of you may have seen recently, we're talking about power. Not just power. We're talking about separation of power. We truly are talking about the 3 branches of government. So everything you've been doing first-year law school all the way through is what we're talking about today, because executive orders, proclamations, presidential directives are executive legislating. And there is nowhere in the Constitution that explicitly discusses executive orders. That's why this is a really fascinating topic, and why what's been going on for the past month and is going to continue going on really creates a lot of opportunity for discussion, dialogue, and analysis. So The separation of powers issue, executive orders go back to 1793. That's when the first one was issued by George Washington declaring the neutrality of the U.S. between France and England. And two founding fathers disagreed about the legality of that. Hamilton said it was legal. Madison said it was the monarchy creep. It was the executive getting too much power. And we continue from that point on. We've had, I believe, over 13,000 executive orders have been issued since. And again, there's no explicit constitutional authority. So what we have with executive orders are, they are directives. There are executive orders that direct to the agencies. There are proclamations, presidential proclamations, which are generally more directed to private citizens. Again, the legality of it, some of the rest of the panel will talk about. Well, let me just talk briefly. I know a lot of people came, this was scheduled a couple weeks ago when the talk was primarily the immigration executive order in terms of people from 7 countries and how that was going to play out. Things have moved since then somewhat, but that's an important order that I know Professor Welch will talk about and Professor Norchi and Professor Baum. But I also want to mention that as part of that, there's a lot of administrative process that goes on. So after the executive order, 2 days ago, the Department of Homeland Security issued 2 implementing memorandum or guidances. And those of you who took LegAd with me in the fall recall that guidances and policies do not have the force of law, technically. There's an executive order, that's a little unclear. That's what's being litigated. And secondly, another EO, executive order, I do want to mention because it has not gotten as much press, but impacts probably 3/4 of what you're doing in law school, is what I call the 2-for-1 executive order, which is for every new regulation or rule that is being developed by an agency, 2 have to be repealed. And the executive order says that you are not to increase, quote, incremental costs. Now the problem with, in part, the executive order is that, remember from LegAd, we do not like ambiguity. The term incremental cost is not defined in the executive order, nor is it defined anywhere else that one could reference. And so it is the subject of a lawsuit. Public Citizen, NRDC, AFL-CIO have already filed a lawsuit, and that's one of the claims. But what's interesting also, again, for those of you doing business or other types of work here, is that the executive order says you cannot consider the benefits of a regulation. So the whole concept that you may have studied in college or in some of the courses here of cost-benefit analysis was just wiped out by that executive order. You are only to do a cost analysis. You only evaluate the cost of a regulation. You can't net out the benefits. Is that legal? That's what's being litigated, and that's what's being debated. So again, and the one thing I want to mention on that executive order is executive orders, guidances, policies, rulemaking generally, they don't come out of thin air. They are supposed to be based on existing law. An executive order cannot create new law, nor can a rule. It's supposed to be rulemaking, a logical outgrowth of existing law. So you have to then take the executive order and say what's the law based on. The interesting thing with the 2-for-1, it's based on a statute that I had not heard of in Title III, Section 301, that basically says the president is delegated authority, can delegate authority to an agency. So that's a fundamental principle, but it has nothing to do with the actual executive order. But that statute is also in the immigration EO and probably every other EO that will be issued going forward. So, and then the Office of the OMB, the Budget Office, then issued an interim guidance on the 2-for-1. We also just had yesterday the transgender policy of the President Obama, former President Obama, repealed essentially by a 2-page letter from the Department of Education and the Department of, actually the AG. And so again, what an executive does without going through Congress can be repealed by the next executive. And so that's, you're going to be seeing a lot of that coming along. So just quickly, two more questions. The Administrative Procedures Act, does it apply here? And what's interesting, again, is that to have the force of law, it has to be either congressional law or delegated authority from Congress to develop rulemaking through notice and comment rulemaking. That's not done with executive orders. It's not done with guidances or statements of policy. So technically, they are not supposed to have the force of law, but there may be some exceptions. And as a practical matter, they do. The executive order is one of these beasts that blurs the line between notice and comment and not. And what's interesting with the Administrative Procedures Act, there's a little-known exception to rulemaking called 553A that says it does not require rulemaking for military or foreign affairs. There's not surprising, maybe surprisingly, very little case law on what that means, and there's a split in the circuits. There was a 1973 DC Circuit case that went one way and a Ninth Circuit case in '83 another, both involving immigration issues, coincidentally, and basically saying it boils down to what are the dire consequences that may come from requiring public notice and rulemaking. So we'll let Professor Welch talk a little more about that. But the last point I want to make is, again, quickly, is if you don't have the Administrative Procedures Act, not notice and comment rulemaking, then what is there? What are the requirements before you promulgate an executive order or proclamation or a directive? And there will be constitutional issues that the remaining speakers will talk about. Is there due process? Those, again, from Ledge Ad, remember what, Joanne, what case?
Bimetallic?
Bimetallic and London University Denver. For the foundation, you see how these students remember these cases cold. And immigration law, though, is almost sui generis. It's a type of law that has been carved out from some of these other general principles, and Professor Welch will talk about that. So let me just go back in conclusion. So the next time that you have a dollar bill, take a look at the back of the dollar bill and then think about executive orders. So what we have on the back of the dollar bill is a pyramid, but I invert it. So going back to the pyramid I showed you at the beginning, because really what you're talking about is chasing down through several layers of legal analysis, what is the basis of an executive order or that two-page letter yesterday on the transgender policy or anything else. And at the bottom, down at the bottom of the rabbit hole, rabbits and holes, you have to chase these issues down. And so we have the Constitution at the bottom. That's the base. That's because if you don't have either the Constitution or congressional legislation at the base of your EO, then you don't have that. You don't have delegated rulemaking, or you don't have the non-legislative rules. They don't have the force of law. Then we have executive orders up here, and ultimately then up here we have what happened yesterday, are these interim guidelines or interpretations of executive orders, which again is sort of far removed from the Constitution or law, but without that base, the whole pyramid crumbles. And that's what Professor Bond will now address.
I didn't know it was spring props.
Here's the dollar.
For the white-elves in this room, right, I hope at least some of that sounded familiar, right? Yesterday we listened to a clip of Hamilton, the musical, and there was a piece of that talked about the Neutrality Proclamation. In fact, what I'm going to talk a little bit about is we'll touch on some of the things we talked about in our class, right? So my general topic is what are the limits on executive powers to issue these orders, right? And I want to divide it into two kinds of limits, right? So one is, we can think of as an internal limit or a separation of powers limit. It's when is the president exceeding the president's authority to issue an order, right? And the framework here comes from the Youngstown case that involved steel seizure of a mill, right? So you had the president want to take over a steel industry, take over a steel mill in time of emergency, and the court there splintered into a bunch of different opinions. But for those of you who were studying this either this year or last year, right, remember Justice Jackson wrote a very famous opinion. And in Justice Jackson's opinion, he said, well, if the president's acting on his own accord, without any congressional approval or with congressional disapproval, then the president's power is minimum, right? If there's nothing in the statute that Congress has allowed him to do something, then he's got to point to something in the Constitution to allow him to act, right? And if there's something in the Constitution As Jeff says, then there's no power to issue an executive order. And so then the question becomes, what are those inherent powers where the president can act without any authority of statute, right? And the court there says, if there's nothing in the statute or the Constitution, you can't act. On the opposite extreme, if Congress tells the president, go ahead and do something, and the president does it, then the president has the most authority. And some of these instances that Jeff points out, we'll see them in the immigration context as well, oftentimes Congress gives the president very broad authority, right? So for example, after 9/11, Congress passes the authorization for military use, right, military force. It gives the president very broad authority to essentially decide what to do, right, how to fight this war. And the court has upheld a number of executive actions, basically saying this authority that you're giving the president, that lets him essentially decide how to run the military, how to execute this war, who were the contributors to 9/11, to define those parties, how to treat people that are captured overseas, right? So all of that authority comes from a very broad grant of power. So the president can point to a statute that's very, very broad. And you see in the immigration context, when Anna's talking, you'll see there that the authority of the president is very broad to decide which people to exclude from the country. Obviously, the hardest category is what if Congress hasn't said yes or no, right? What do you do at that point? What is the president's power then? And the court really hasn't decided this. In the big cases, the court has tried to push congressional silence into one box or the other. So it's not saying that they're silent, but they've done things similar to this, and so they must have disapproved exactly what you're doing. In other cases, they'll go the other way. Say, well, yeah, they're silent, but they've allowed things that are similar to this, so they must be okay with this as well, right? So by pushing into the two big boxes, where you have either approval or disapproval from Congress, well, the court has an easy time not specifying what can the president do when Congress has said nothing, right? But this is an issue that's come up quite a bit. Trying to understand what those powers are. We saw this in the immigration context with President Obama, right? With DACA and DAPA, with deferred actions, where Congress might have said, well, here's the law, and same thing with marijuana enforcement as well. But the president says, here's how I'm going to execute these laws. I'm the president, I'm in charge of the prosecutorial office, and as our prosecutorial discretion, I'm going to decide where we'll put our resources, right? Is that ignoring congressional intent that those laws should be enforced? Or is that an executive action where the president has discretion to decide where to spend the money and which violators of the law to go after, right? Those are all questions that have been raised long before President Trump's orders and will continue to be raised. So that's one set of limits. The other set I'll touch on really briefly is external limits, right? Beyond separation of powers, are there other provisions in the Constitution that limit what the president can do? And that's things like rights, right? So First Amendment, the Establishment Clause, due process, substantive and procedural, the Equal Protection Clause. So generally, we have thought that those two are limits in the president's action. Right? So even when the president is acting with congressional approval, if he runs into another limit, First Amendment, Establishment Clause, that's another restriction of what the president can do. Now, the big open question there is, how broad is that discretion when it comes to foreign affairs or immigration? So in some contexts, at least the court had historically hinted that with foreign affairs, we'll give the president more power. There's less of an equal protection concern when we're dealing with a topic where the nation should speak with one voice on issues like immigration. And I think Anna will speak to this as well. You know, how much of a equal protection challenge can certain classes of immigrants bring, and what the role of the court here is to decide those equal protection challenges. If you listen to the Ninth Circuit oral argument, that was one of the big focuses in that case. So I'll let Anna speak, and if you have more questions about the constitutional limits on immigration and foreign policy, we can come back to any questions.
All right, so thank you, Eliza, and the Maine Law Policy Group for organizing all of us. I'm going to rather quickly move you through the immigration executive order. So there have been a number of orders out of the Trump administration. But perhaps the immigration orders, I think, have received the most attention of the various orders, and I think for good reason. Each represents a dramatic change or shift in policy from what we saw under the Obama administration. So today I'll begin with giving you some legal context for these executive orders, beginning with a quick overview of these orders themselves, and then turning to some of the legal challenges that they present. There are two orders dealing with interior enforcement and border security.
And these orders haven't received as much attention, although that's changing. New York Times just had a front page article on the Interior Enforcement Order. And I think that's changing given the humanitarian and legal issues that will arise in the implementation of those orders. The orders both say many things, some of which I think are worthwhile to highlight now. So they set new priorities for enforcement. So there are approximately 11 million individuals in the United States who are here undocumented. And the Department of Homeland Security has said that they have the capacity and the will to deport about 400,000 a year. And as Professor Baum mentioned, the executive branch, through this exercise of prosecutorial discretion, can then decide who to prioritize and then set priorities within that 11 million. And Obama had prioritized the removal of more serious immigration violators, folks who had committed more serious criminal offenses, and said specifically that he would not prioritize folks who have clean records, folks who have strong ties in the form of U.S. citizens, children, or spouses, or lawful permanent resident children or spouses. The recent executive order on interior enforcement establishes new priorities, rescinding most of the Obama administration's priorities, and essentially makes everybody here without authorization a priority, including individuals who have been charged but not convicted of crimes, individuals even suspected of having committed crimes. So that's one. The order also expands interior enforcement. So it allows immigration officers to make arrests and subject individuals to what's called expedited removal, meaning that the decision in terms of who to remove is made by an immigration officer and her supervisor. There is no right to appeal that decision. There's no right to judicial review of that decision. And often the removal happens in less than 24 hours, so it's quite immediate. Under the Obama administration and all prior presidents, expedited removal was only applied within 100 miles of the border, and for people who've been here for less than 2 weeks. Otherwise, for most people in the United States, you were entitled to a hearing before an immigration judge, an independent immigration judge with the Department of Justice. But now the administration has plans to apply expedited removal throughout the interior of the United States for people who've been here for less than 2 years. So it has sparked incredible fear amongst the immigrant community, and it will likely be litigated given the procedural due process issues that it raises, especially with respect to people who do have strong ties here to the United States. The orders also call for expansion of immigration detention, including to women and children who are fleeing violence from Central America. More resources, significant hiring of ICE and immigration enforcement officers, and also the encouragement and pushing for more agreements with local law enforcement, deputizing local law enforcement to carry out immigration enforcement. Okay, so the other order that I'm sure you're all quite familiar with is the order that's entitled Protecting the Nation from Foreign Terrorist Entry into the United States. This is the so-called Muslim ban, and this has definitely been in the news. And it includes many provisions. Again, I'll highlight the big one. So suspending the entry of all refugees for 120 days, barring Syrian refugees from coming in, indefinitely barring them, blocking entry to the U.S. for 90 days of citizens from these 7 predominantly Muslim countries, including the order has barred green card holders from coming in and those with valid visas. And it reduces the number of refugees, once it does reopen refugee admissions, reduces it from 110,000 that was set by Obama for the fiscal year 2017 to 50,000, so a dramatic decrease. So that order was signed on January 27th. It went into effect immediately, which I'm sure you all know created incredible chaos, and then it was immediately litigated. A federal judge in Washington issued a stay for the entire country, and then the government appealed it to the Ninth Circuit, which upheld the stay. The government has indicated, although there's some contradictory information out of the Trump administration, that they're not appealing the Ninth Circuit's decision, but instead are issuing a new order, and I'm really checking the news every moment to see when is that new order coming out. But some information has been leaked about that order. We know that it will likely continue to target those 7 countries, will likely remove green card holders from explicitly being excluded, and so I think we'll see, and likely will maintain that reduction in the number of refugees from America. Okay, so now let's turn to some of the legal issues that these orders present. And a lot of my students have asked, can you really do this? Is this possible? And in many respects, this is really uncharted territory. So as Professor Thaler and Bob mentioned, immigration is a unique area, and that the courts have often been quite deferential to the laws and policies that both the executive and the legislative branches have moved forward. And especially they're deferential in the context of national security, so when the national security grounds are raised to justify these laws and policies. And this deference to the political branches when it comes to immigration falls under this doctrine called the plenary power. And this doctrine of plenary power, for those in my immigration class, I can ask you to define it, but I won't. Essentially holds that the legislative and executive branches enjoy sole power to regulate our immigration system, who can enter the United States and whom we can force out of the United States. And that this power is inherent to our national sovereignty, and that both of these political branches enjoy pretty broad discretion over foreign affairs, and therefore they can decide who can enter the Union. So I tell students at the beginning of the semester that, again, in the immigration realm, laws that might seem unfair or idiosyncratic often are upheld under this doctrine of plenary power. And it's important to note that the Muslim ban isn't entirely unprecedented, though it is unprecedented sort of in our modern era. So Muslims are really the new Chinese from over a century ago. So in the 19th century, there was a ban on the admission of Chinese immigrants. And the laws and policies banning Chinese were actually upheld by the Supreme Court under this doctrine of plenary power. And you'll actually see that the current administration and the government attorneys are arguing in support of these executive orders, bringing in some of this old case law and arguing that there's no right to even a judicial review of these orders, that they have enjoyed unfettered power. Quoting back to some older cases, whatever the procedure authorized by Congress is, it is due process as far as an alien denied entry is concerned. So what this means is that admission into the United States is considered a privilege, not a right, and so for many trying to come in, there are no due process rights that attach. It's a privilege, and the government can decide who can come in. Once you're admitted, there are due process protections that apply, and that varies depending on the person and on the context. But the critical point here is that the analysis doesn't stop at these older cases where plenary power was really nearly absolute and unfettered. While our political branches do enjoy pretty broad authority to control our immigration system, over the last several decades, we've seen a significant chipping away of that plenary power doctrine, and these laws and policies are absolutely not immune from judicial scrutiny, as I think the government would like us to believe. The Supreme Court has, for instance, stated that we cannot indefinitely detain immigrants who we are seeking to deport from the United States. We can't deny entry to U.S. lawful permanent residents of these green card holders without notice and a hearing. And this is likely where the White House counsel quickly came out and said, well, we're not going to apply this ban to those individuals. And despite, again, the government's assertions that these orders aren't subject to judicial scrutiny, the Supreme Court has said that they certainly are, and especially where there might be questionable motives such as racial or religious animus. And we can talk more about that maybe in the Q&A. And absolutely, in terms of, to the extent that this ban is applied to asylum seekers and refugees at the border, folks who are trying to come in and are fleeing persecution, it's in direct violation of our international treaty obligations and in our domestic law with respect to asylum seekers and refugees. So under the 1951 Refugee Convention and the 1967 Protocol, we cannot deny entry to asylum seekers without an independent hearing on their claim. So that's a segue to Professor
Norchi.
We'll talk about it another Thank you.
I too would like to thank the organizers of this session, the Maine Law Policy Group, and Eliza, thank you very much. And when I saw the title of the panel, what came to mind immediately was Executive Order 9066, which was signed in 1942 by Franklin Delano Roosevelt, and which resulted in the internment of about 120,000 men, women, and children of Japanese ancestry. Well, I'm here to talk a bit about the powers of executive orders from the perspective of international law. So we're a few months into the new U.S. administration, and we have a Trump effect on the international legal system. As candidate now as president, Mr. Trump, through executive pronouncements, policy, communications, and tweets, has been agitating the international legal system to the point of unraveling. Executive orders intended to modify or withdraw the United States from legal obligations previously undertaken will affect the United Nations, human rights, refugees, international trade, the environment, and any lingering limitations on the use of force. Under U.S. law, an international agreement, so not an executive order, but an international agreement, falls into three basic categories: treaties, congressional executive agreements, and sole executive agreements. Now, in most circumstances, the President can withdraw unilaterally from a sole executive agreement or a political arrangement, such as the Paris Agreement, that was concluded in December 2015. President Trump, as Professor Welch noted, has issued 3 executive orders that bear on immigration and also human rights. And these pose dramatic restriction of access to asylum and other immigration protections that have long existed in the United States. As Professor Welch noted, these breach the 1951 Convention relating to the status of refugees, also the International Covenant on Civil and Political Rights, the American Convention on Human Rights, the International Covenant on Economic, Social, and Cultural Rights, and the Convention on the Rights of the Child. Parties to the 51 Convention are obligated to observe a principle called non-refoulement. In other words, the parties can neither expel nor return a refugee to territories where life or freedom would be at risk. Any expansion of expedited removal exponentially increases the chances of the principle of refoulement. Additionally, any criminal penalties espoused in these new policies violate international law and fail to protect refugees' basic rights. International trade. International trade agreements and the global commerce system is at risk. President Trump is terminating agreements pertaining to international commerce and trade, beginning with the Trans-Pacific Partnership and the North American Free Trade Agreement. The TPP was signed by President Obama. It never entered into force. Mr. Trump's unsigning the TPP, which was the largest regional trade accord in history, as a matter of unilateral executive power, was very straightforward. It went poof with the stroke of a pen. Then there's NAFTA. Now, NAFTA provides for withdrawal with 6 months advance notice to other parties. NAFTA is a congressional executive agreement implemented by Congress through the NAFTA Implementation Act. It is unclear whether Mr. Trump could withdraw without the support of Congress, but do recall that the party that controls the executive branch also controls the legislative branch. If the United States voluntarily retreats from the economic world stage, other countries will not miss the opportunity to fill the vacuum left behind, notably China. Mr. Trump has even suggested that he would withdraw from the World Trade Organization. The WTO regime comprises distinct multilateral trade agreements. The WTO treaties with congressional executive agreements executed and implemented by Congress, hence denunciation would also involve the Congress. Inevitably, withdrawal would significantly affect American firms' ability to access foreign markets, would raise customs duties, tariffs, and regulatory barriers. Further, American firms may not be able to challenge expropriations and other commercially discriminatory actions before international tribunals. Hence, global trade and commerce would be rendered unpredictable. Now, the most important function of international law, I would submit, is the prevention of war and limitations on the use of force. The Joint Comprehensive Plan of Action, JCPOA, also known as the Iran nuclear deal, was concluded by the United States, the EU, European Union, and 5 other countries. The objective is to ensure that Iran could not build a nuclear weapon, and in exchange, that government receives sanctions relief. Now recall that Mr. Trump has termed the JCPOA the worst deal ever negotiated. Ending it is his #1 priority. Now the JCPOA is a political commitment that turns on technical and thus far very successful verification measures. U.S. denunciation of the deal would be harmful to Western companies who seek to do business in Iran, harmful to the legal regime for the control of nuclear weapons, And what signal would this send to paranoid elites who control nuclear weapons? Now, the Trump administration will attempt to denounce ratified treaties under which the United States has assumed certain legal obligations. The United States Supreme Court has not settled the question of whether the president can unilaterally withdraw from treaties or congressional executive agreements. I draw your attention to two cases, Goldwater versus Carter and Kucinich versus Bush. However, whether any state can withdraw from, denounce, or terminate a treaty is not merely a domestic matter. It is also a matter of international law, which requires either compliance with a specific withdrawal procedure set out in the treaty, or compliance with a very narrow set of exceptions. Under the 1961 Vienna Convention on the Law of Treaties, a state may withdraw from, terminate a treaty if the treaty itself provides for withdrawal or termination with the consent of all the parties. Absent a withdrawal clause, and these vary quite widely, any failure to comply with the Vienna Convention procedures renders a purported United States withdrawal without legal effect to the international community. Now to finish here, flouting international law has blowback consequences. Breaches and flouts encourage similar behavior by other states, often powerful states. To the extent the United States breaches the 1951 Refugee Convention, other states, notably across Europe, will likely suspend the convention. In the first months of the Trump administration, Russia has violated the 1987 Nuclear Force Treaty, the INF, by direct missile deployment. A Russian surveillance vessel sits in waters 30 nautical miles from the east coast of the United States. Russia continues to breach the UN Charter by its annexation of Crimea. Strongmen in Turkey suppress expression. In the Philippines, a strongman executes citizens extrajudicially. In China, reasserts aggressive maritime claims. And let's not forget that North Korea continues to threaten nuclear war. So our principal goal of international law is to ensure a measure of predictability in what is an otherwise anarchical international system. However, presidential pronouncements, signals, and tweets erode the international legal system because they may be taken as authoritative by other members of the international community. And as exclusive self-interest displaces the presumed inclusive common interest, the public order of the world community degrades. So what we may be watching, what we may be witnessing in the coming couple of years, is the waning of a liberal international order that was built on the ashes of World War II and which enshrined respect for law. So the question I leave you with is, will the legacy of this administration be an unraveling of that international legal system? Thanks.
Okay, so we have 10 minutes, maybe 15, that we can take with the dean for questions. So can you just raise your hand?
My question is for Professor Baum as to what prediction he might have as to President Trump's Supreme Court nominee and his opinions and impact that would have on executive orders.
Yeah, I mean, in terms of the nominee's prospects, I think he's going to get confirmed one way or another, whether it's through overcoming a filibuster or not. So I think there's a very good chance that of course, she'll be on the court. As far as his view, I don't know if Jeff, if you have thoughts on kind of his view on administrative powers, and my sense is he's willing to bring back some of the non-delegation doctrine and preserve more of the legislative power than the legislature. So I think his general worldview is to say the legislature has less power to give away some authority to the president, to the extent that the executive orders often look like legislation. If you pick up an executive order, often it looks like a bill, and sometimes they're just letters. Sometimes they have, whereas something happens, so they look like a piece of legislation. To the extent that Justice Gorsuch would be more a formalist in the court would say, look, this is legislative power, it should be done by the president. I think he'd be putting in place more of a check on the president's executive orders.
I was going to say, I mean, people are speculating, certainly, and they've been reading his decisions very carefully and trying to draw, like, from entrails, trying to predict how he's going to act. But as a practical matter, he did write I think it was a concurring, maybe it was a dissenting opinion, I don't recall, on the Chevron doctrine. And basically, he's been likened to Justice Scalia, who he would replace. I've seen analysis that he may be more like Justice Thomas, that he's much more of an originalist than possibly even Justice Scalia was, and that Justice Scalia was a defender of Chevron ultimately in terms of deference to agencies and rulemaking properly delegated. Justice Gorsuch may not agree with that, and Justice Thomas and some others have raised questions about how much can be delegated or deferred to in terms of agency action. Where it ultimately comes back to, I think, is if he's truly looking back at the original Constitution and trying to say how much power does the executive have compared to the other branches. I wasn't being facetious when I talked about the separation of powers and the fact that Madison and Hamilton, a couple of years after writing the Constitution, disagreed over the scope of executive authority. So we're talking really down to root level, and it will be very interesting. So it's hard to predict, but I think, and I don't say this again just to say that how important law school is, but I think it is becoming increasingly important for lawyers and others to have a grasp on all these issues, because I have no doubt they're going to permeate throughout our society for the next number of years, even after President Trump is no longer President Trump. And because there'll be a lot of judges who are going to be appointed in the next few years. So both domestically and internationally, there's huge consequences here. All of it involves law, and all of it is relatively uncharted, which can sound shocking in the 21st century, but means that creative lawyering is what's called for.
I have a question. Oh, sorry.
My question is for Hannah. So I've heard it argued that if President Obama actually created the machinery to allow for record deportations during his presidency, like you mentioned, the capacity, I can't remember the exact number, but I know that for most of Obama's presidency, he was able to hit that limit. So I guess my question is, even though Trump is sort of expanding the prosecutorial discretion of ICE officers, how the actual net result is going to be any different if there's still that cap and you're still going to be able to see record deportations just like we did under Obama?
Yeah, I think that's a great question. I think Obama has a reputation of being the deporter-in-chief. He's deported more immigrants than any prior president, about 2.5 million. But this still is a dramatic change in the expansion, or sort of the how he's going to go about it. And I think the biggest change is, again, this expansion of expedited removal. Again, where it only, in the past, it applied to within 100 miles of the border and for those who've been 2 weeks. That's pretty limited. But now if we're talking about expanding it into the interior to the total 11 million people here, and you can do it pretty quickly without going before an immigration judge. And that's where things really slow down, is an immigration judge, it can take years to get through that process. I think President Obama recognized that for people who've been here, I think 2/3 of the undocumented population have been here for over a decade, that they're entitled to some due process, right, to a notice and a right to that fair hearing. And this is that significant change. And so I think he can bring about some pretty dramatic change and increases, provided he can hire some additional, I think it's 10,000 additional officers to execute this order. But I think we can see a pretty substantial change.
My question is to know how the executive order will affect the U.S. asylum system.
So we have a lot of clients who are very fearful that the executive order, all three of the orders impact them. But the reality is, and going back to what some of the earlier comments, is that this administration can't change laws, and he can't get rid of our domestic laws on asylum. And so folks who've applied for asylum, folks who are in the United States and seeking asylum, he can't impact them. Now, I think what he can impact is detention. So at our southern border, a large number of women and children coming up fleeing persecution in their home countries, and he's indicated in the interior enforcement order that he wants to increase the number of detention beds and detaining these individuals. And I think that there's a lot of fear of expedited removal being applied to those individuals at the border. Again, where you don't have that right to appeal it to a judicial, to court, to immigration court. I think there's fear that ICE or NCBP officers or enforcement officers within immigration will not fairly review these requests from asylum seekers at the border. But for folks in the United States who have applied for asylum, he can't take away the right. It really hasn't changed, and I don't expect it can change. And if it tries to, they'll be subject to intense litigation for asylum seekers in the United States.
Can I just add one quick thing, which is that one thing we haven't talked about is as an aspect of the original executive order that is probably coming back this week or any moment, as Anna says, is the 7 countries. And that the 7 countries on that list are not the only 7 countries that may end up on that list, and that there was a provision in the executive order which said that within, I think it's either 90 or 120 days, the head of Homeland Security can add countries to that list if he has not received satisfactory or sufficient evidence of the visa screening policies of basically all countries in the world. When I said no vagueness, no ambiguity in the law, again, not being facetious, if you read that executive order, there are no criteria at all guiding the head of Homeland Security as to what is sufficient or satisfactory for visa screening in the 200 countries around the world. So if he chooses to add 20 more countries to those 7, based on whatever the criteria may or may not be, that's going to have a huge impact as well, and will presumably be subject to more litigation.
And refugees seeking admission into the United States will absolutely be impacted from Syria, where it's indefinite, depending on what this new order looks like. But if these 7 countries and additional countries are targeted, then the refugee admission of these individuals would also be halted. But again, refugees are those who are seeking refuge to the United States, but they're abroad currently. Asylum seekers are those who made it into the United States, whether legally or illegally.
Can anyone speak on the proposition that those seeking entry into the United States will be subject to having their Facebook accounts searched, their social media, their phone contacts?
We're hearing it happening. I think that's the First Amendment issue.
Yeah, I mean, that goes back to the questions of to what extent the constitutional protections apply abroad, right? So that's part of what the fight has been about, the litigation's been about, because most people agree that when somebody's here, they're people, right? The Equal Protection Clause says it applies to all people. The question is, how does that principle apply to somebody who's not here, right? Is there any protection for somebody who's abroad? And as Anna has mentioned, the general rule for consumer immigration is none of the rights really apply, which is why the Establishment Clause has been such an important hook, because there, the rule has generally been you just can't pass laws that either establish religion or free exercise component that discriminate against religion. And so it makes it a little bit easier to bring that claim by almost anyone who's here, whereas it's hard to come up with both people with standing and anyone who can bring a challenge to an Equal Protection Clause when it doesn't apply to you. Right? So that makes the Establishment Clause piece so much more important, because both the standing principle is broader there, and the challenge can be brought more in the abstract to a law, kind of generalized grievance that you can't really bring under the First Amendment if it doesn't apply to you.
I think the problem too with the leaked memo is that those provisions within the executive order that specifically prioritize one religion over the other, there's talk of getting rid of that because of the constitutional concerns that were raised.
Based on that conversation, the intent behind, even if the executive order changes, but it still stays relatively the same, isn't the intent behind it still the same even though he's changed it? I mean, isn't there still evidence? I think the Ninth Circuit talked about Rudy Giuliani's interview on Fox News. I mean, that still exists regardless if he changes a few paragraphs in the new executive order. So would it still apply?
It may still apply, but again, the question will be, so what, to some degree, because again, a couple of those cases that I mentioned earlier and that were sort of referenced to, if you have a situation of national security, and that's what Anna was talking about too, if the executive branch says that they need to do this because of national security concerns, the exception, for example, in the APA 553A, the way it's been interpreted is that if something may cause dire consequences to the country, then the executive is pretty much given, not carte blanche, but a lot closer to that. And that's somewhat what the Youngstown case is talking about. So this is the slippery slope. How dire are the consequences? And if the executive branch can show that it needs to do this because these particular countries have no proper screening for who goes across, who gets on airplanes, for example, then, I mean, that's part of the argument. I'm sure they'll have other arguments, but, so certainly the intent will be relevant, whether it carries the day, though. Honestly, that Ninth Circuit decision didn't spend much time on that. They wrote the most on standing, and then the second issue was reviewability. Procedural due process was third, spent no time on basically equal protection or establishment or procedural due process.
Well, you're right, Shannon, that intent is a big part of the inquiry, right? So to decide what level of scrutiny we apply. As Jeff says, maybe the government satisfies strict scrutiny. And I would go back to where Charles started, right? So he mentions the Korematsu case. There the court is applying strict scrutiny, right? But it's very deferential to the government. So you might have that here. The court might say, well, yeah, there's intent here, but once we actually get to the level of scrutiny, the court might still say, well, let's defer to the president or president and Congress if they agree that these individuals are more dangerous than these other individuals. So those are all open questions about both the level of scrutiny to apply and how to apply it in this context.
And I think even if the court disagrees with the policy behind this, I think that they're not apt to question sort of those political questions, right? And so they do tend to defer. And I think if they were to say, no, you can't do this, then think about future presidents in a time of real crisis, and then them being hindered in terms of being able to institute someone.
All right, I think we should probably end there. I'm sorry. Is it a really quick question? No.
We'll talk to you afterwards. How's that?
Again, this is a class in here at 1:15. I want to make sure that we're not taking Professor. Thank you all.